G20 Summit has formally declared a framework promoting international rulemaking with regards to the digital economy. In the midst of the corona crisis, I found it more important to discuss how we can maintain and strengthen our cooperation in the field of data privacy at the global level.
It's my pleasure to introduce you to Professor Dr. Henrike Weiden. She has given lectures at numerous universities in Germany and Japan, mainly in the field of law and digitization, with a very strong focus on data privacy.
Thank you very much for your kind introduction and for inviting me to give a brief presentation on the EU-Japanese cooperation in privacy matters. Since we are all using our screens to make this happen, let me briefly introduce my topic by a short animation that one of my very talented students created for us. Unimask's commercial behavior is within the territorial and material scope of this European regulation, so GDPR is applicable. Undisputedly, Unimask is permitted to process my personal data as far as it is necessary to perform the contract of shipping masks to my physical address in Germany. For this data and for this purpose, it is sufficient to be transparent about processing my data in the obligatory data privacy policy to be published on the website. As far as the additional information, such as my browsing history, is concerned, data that is not considered necessary for the use of the website, Unimask requires my informed consent, as the European Court of Justice made clear last October. But let us take a look at the cross-border transmission of information. What does it mean when personal data from the EU need to be transferred to a third country outside the European Union, for example, to Japan? It means that on top of EU privacy compliance for processing personal data, the transfer has to fulfill specific requirements under GDPR. As you can see from this chart, transfer of personal data collected within the Union to third countries are permitted on a variety of legal grounds. Some of them are easier to handle than others. Some of them are legally safer than others. Let us compare the options. Among those legal instruments that allow for cross-border transfers with no additional authorization by the competent authority, there are standard data protection clauses. Formally, they can be adopted either by the European Commission or by the competent national authorities with the Commission's approval. Standard data protection clauses are widely used in practice. They are readily available and are certainly a good option as long as you use it for standard operations, because using established standard data protection clauses means your processes also need to be standard, where you generally cannot change the clauses. If you want to avoid additional authorization requirements, you only have to fill in the forms. This also means the more complex the business operation or the purpose of transferring personal data is, the less likely it is that you can make use of standard data protection clauses though. Looking at our example in this little animation we watched in the beginning, or in the case of Unimask, the transfer of the personal data from the EU to the headquarters in Japan would easily be covered by standard data protection clauses. However, forwarding the information to the university in Fukuoka and to the business partner in Korea is quite another cup of tea. This is not as casually covered by the Commission's standard clauses. Using the desired personal information for academic research purposes, the university is not bound by the relevant provisions of the Japanese Act on the Protection of Personal Information, APPI. It is therefore unlikely that it will agree to submit to even tighter restrictions than APPI, how to use personal data under standard data protection clauses. Let me mention, and in the case of the Korean business partner, it's a matter of convenience and legal security. When he imports personal data from his Japanese partner, he's used to relying on the data subject's consent to the transfer, because this is what APPI requires in the case of a cross-border transfer. Meaning once the Korean operator has received data on Japanese consumers from Unimask, he can freely choose a new utilization purpose for this data according to APPI. He's not bound by the initial purpose of collecting the information. Now, if this operator in Korea agreed to sign the standard data protection clauses, not only would he have to install a comprehensive compliance scheme for a potentially small fraction of his database. It will only cover data that originated in the EU. But he would also assume full liability risk for the case of an infringement of the standard clauses. What is more, Korea is signatory to the APEC Cross-Border Privacy Rules System, CBPRS, a multilateral agreement that Japan is also party to. Under this agreement, the Korean business partner could theoretically receive personal data from Japan much more easily. Against this background, it's not very likely that Unimask would be able to convince the business partner nor the university to sign the European Commission's standard data protection clause. After all, even if the business partner in Korea was willing to sign, we were counting the chickens before they're hatched, because under GDPR, Unimask would only be able to forward part of the personal information collected from me. One of the most valuable information, my browsing history, maybe I've been browsing on websites about respiratory diseases, would require my consent, not only regarding the collection of this information, but also with respect to transferring it all the way to Korea. Fair to say, in this example, we're dealing with a business situation that is already too complex to be easily handled under the standard data protection clauses. Typically, though, the Japanese company in the animation and Unimask would apply for approval of so-called controller binding corporate rules, if they will only need to transfer personal data within their own enterprise. But as the title suggests, this instrument is designed for corporations to facilitate their internal data transfers between business units, such as HR data to be transferred to the HR department, or customer data to be used by the marketing unit, for example. In our Unimask case, we're looking at a Japanese corporation and its partners in Japan and abroad. Together, they don't qualify for binding corporate rules. Plus, because of the need for their approval by the competent authority, this option is one of the most costly and time-consuming ways to ensure GDPR compliance, always limited to selected groups of personal data only. This is only worth the effort when you intend to make use of it in your everyday business on a larger scale. Of course, you can always consider individual contractual clauses between the data processor and each recipient of private data to ensure appropriate safeguards according to GDPR. However, as you might know from your own experience, this can be as lengthy and yet as expensive as approved binding corporate rules. Well, they equally have to be authorized by the competent data protection authority. And this usually requires a lot of drafting and redrafting, which usually comes with multiple negotiation rounds among business partners. So in practice, this is what especially larger corporations actually tend to do. They use the European Commission standard data protection clauses as a starting point and alter its specifications in accordance with their own business case and partners. And then they file their so-called intergroup privacy agreements for approval. For larger companies with multiple usage of these agreements, this investment in time and money seems to make sense. However, for smaller enterprises, it's usually not worth the effort. So let us turn our attention to the remaining option, a transfer based on the European Union's adequacy decision of January 2019, which went hand in hand with Japan's whitelisting of the EU according to API. The European adequacy decision for Japan confirms that Japan ensures an adequate level of protection for personal data. Adequate hereby means comparable to the EU. Consequently, a transfer of EU data under the adequacy decision does not require any specific authorization. Where a country has been decided to ensure an adequate level of protection pursuant to GDPR, a transfer to this third country should be as easy as a transfer within the EU, within the internal market. That's the idea of an adequacy decision. But in the case of Japan, which was the first and so far the only case that a country was granted an adequacy decision under GDPR, a few restrictions apply. They're called supplementary rules. There are 5 supplementary rules annexed to the adequacy decision. They lead to a rather complicated, if not impossible, application to our slightly complex case at hand. But let us first take a look at our simpler case from the video we watched together. Animation. Here we encountered a company that merely wanted to transmit personal data on German consumers to be processed by the website owner's marketing unit in Japan. For this case, the adequacy decision comes quite handy. Even though at the Japanese headquarters, all handling data units have to ensure strict separation of EU data from personal data generated in other countries, such as Japan. One of the reasons for that is supplementary rule number 2. This supplementary rule overrules APPI's differentiation between retained data, personal data that is stored longer than 6 months on the one hand, and non-retained data on the other. Data subjects of non-retained data are generally less protected than the others. But still, in this plain example, the Japanese company might as well transfer personal data under the adequacy decision simply to avoid authorization proceedings in the European Union. That's okay. However, for our example of Unimask, it's a different matter altogether. The reason is twofold. First, there is supplementary rule number 3 that alters APPI with respect to the need to obtain the data subject's consent in the case of a new utilization purpose after a transfer to a third country. Different from APPI, this supplementary rule number 3 requires the initial data recipient, in our case, Unimask in Yokohama, to thoroughly document the purpose for which the data have been sent from the EU to Japan. And should anyone, Unimask or any of its business relations, ever change this purpose, the data subject's consent is mandatory. Unless the new purpose is compatible with the initial one, which doesn't apply to the Korean company's marketing purposes. Now I'm trying to picture myself being requested to consent the utilization of my browsing history by a Korean company for their own marketing purposes. Why should I agree to that? You see, supplementary rule makes a data transfer from the EU to Japan and onward to Korea under the adequacy decision in cases like this practically impossible. Second, there is supplementary rule number 4. As seen on one of the previous charts, APPI paves the way to 4 different options for a transfer of personal data from Japan to another country. That is, the data subject's consent, or the recipient's country is on Japan's whitelist, which doesn't apply to Korea, or the recipient's country is a signatory to the APEC data privacy rules, the CDPR system, which does apply to Korea, but is not acknowledged by the adequacy decision. Or if a bilateral privacy agreement encompassing all necessary privacy measures in accordance with APPI is signed. This latter option, a bilateral agreement, is most commonly used, even though this has to be drafted in the light of the supplementary rules where EU data are involved. This doesn't exactly make negotiations between Japanese and non-Japanese partners easier, as you may assume. Looking at the option of the data subject's consent, we have to apply supplementary rule number 4. It adds another transparency requirement to improve the quality of this consent. Prior to consenting, the data subject has to be given information on the circumstances surrounding the transfer necessary to the principal, to the data subject, to make a decision on her consent. What does that mean? It means that Unimask would have to obtain my consent on the basis of comprehensive information to the effect that my personal data will travel via Japan to the Republic of Korea in order to enable Unimast's business partner to provide for tailored direct advertisements based on my previous internet research on health-related websites. Well, my first thought would be, isn't South Korea the country with which the European Commission has been negotiating for years now, yet still not having accomplished an adequacy decision? I doubt that I would give consent to this data transfer. What we can see from this supplementary rules application to our case is the adequacy decision with its supplementary rules is more an obstacle to data transfers from the EU to Japan than a facilitator. The adequacy decision cannot tap its full potential. With its supplementary rules, its prime purpose to ease data transfers from the EU to Japan is underachieved. The European lawmakers' idea and desire is that by adequacy decisions, the level of protection of natural persons ensured in the European Union should be maintained even in cases of onward transfers of personal data from third countries into the world. This makes the EU an extremely unattractive source of personal information. Consider the bulky luggage that personal data carry when traveling from the EU via Japan to Korea. Wouldn't you rather return to the pre-adequacy decision practice and walk the extra mile to achieve an intra-group agreement, or refrain from using EU personal data altogether? Regrettably, but understandably, this is what corporations of all sizes still tend to do, as far as I can see. More than 1 year after the adequacy decision has come into existence, they negotiate bi or multilateral agreements, have them approved, and try to convince each and every new business partner to submit to this expensive tool for transfers. Or they renounce old services that require EU customers' private data. Considering a Japanese cabinet decision on the amendment bill of APPI of last month, I do see a light at the end of the tunnel. Apparently, the Japanese lawmaker is in the process of amending APPI with respect to the limited data subjects' rights in the case of non-retained data. And also with respect to limiting data recipients' possibility to freely pick a new utilization purpose, for the time being, at least in the case of national data transfers. This way, the very strong supplementary rules number 2 and maybe one day even 3 are potentially on the verge of losing impact and practice. We will see. After all, if you ask my advice, I would closely monitor current promising developments. Does the Japanese lawmaker, the national legislation, undergo any further amendments that ease the application of the adequacy decision? And what is the outcome of the EU's periodic evaluation of the adequacy decision? The first one is due next January 2021. We might witness future improvements in the application of this theoretically extremely supportive legal instrument. In this case, it would be highly recommended to be used. Until then, we either keep business relations standard and apply standards, or we invest in individual solutions and have them approved by the competent authorities. Ganbatte kudasai.
Thank you very much. There's one question coming from the audience, Mr. Wegmann of Gleislutz. I'm just going to read his question. From our practical experience, there's a significant disconnect between the obligations under the law and how they are enforced. Have you any experience with whether German data protection authorities try to enforce the provisions of the adequacy decision in Japan? Or do the Japanese authorities enforce these provisions?
So far, I haven't heard of a single case that the well, the adequacy decision is not even enforced, but the supplementary rules would have to be enforced. I think this will be more transparent in the course of the first evaluation, which is due next January, evaluation of the adequacy decision, which is interestingly enough already after 2 years, a 2-year period after its entry into force, instead of a 4-year period, which applies in other cases of adequacy decisions. So I think we'll learn a lot about that in due course, well, by publication of this in this first evaluation. As far as I can see, PPC is not enforcing the adequacy decision or its supplementary rules on the Japanese side, because it's not its prime interest. It's as far as I can see, it's PPC's view is that they contributed to the enactment of the adequacy decision by formulating these supplementary rules in order to, well, achieve the status which the Japanese lawmaker has been preparing for years. But I don't see any activities in terms of enforcing the supplementary rules so far.
We would like to keep the virtual room open so you can continue with your conversations. If you have any further questions, you could just stay on the phone, so to say, or you could hang up and communicate in writing with the chat room. Once again, thank you, Professor Weiden, Consul General Kimura, Dr. Gump, and all of you for participating. We wish you a successful, healthy day and a good night in Japan.